Okay, good afternoon, everybody. I'm Samantha from the Law Offices of Samantha Wolfe, and thank you so much for joining us this afternoon. It's the next part in our virtual seminar series that we do monthly. So I am going to talk today about special needs planning, and what I'm going to do is we're going to go through the PowerPoint slide, and then what I'll do is we will post this after the fact. We're going to post it on YouTube and Facebook. So if anybody has any questions, you're welcome to check that out. So that being said, I'm going to go ahead and share my screen. Okay, so our office is located at 20 East 6th Street in Suite 206 in Waynesboro, and you can reach us at 717-655-2676. We always offer consultations, so if anything I talk about today or any of the other videos that you check out, if you have questions or concerns, you're always welcome to give us a call. We'd be happy to set up a time to talk with you. This is our mission statement, and I always like to start off our virtual seminars with reminding everybody what our mission statement is. And we try to do our 4 core principles, and we try to implement that in the way we represent our clients. And today we're talking about the A and the R of our care in the mission statement. So we're going to be advocating for you and your family in times of crisis. And today we're specifically going to talk about special needs planning or supplemental needs planning. When I talk about that, those two words are interchangeable: special needs planning and supplemental needs planning. We're also going to talk about reinforcing your estate plan with asset protection strategies as it relates to special needs planning. Today, we're talking about how to protect that special someone when they can't protect themselves. And I thought it might be helpful today to start off with 2 stories, because I always think that they help drive home the importance of this type of planning. So they're actually 2 personal stories. One is in my personal life, and the other is actually here at the office. An experience that we had not too long ago that I wanted to share with everybody, just because I think this is an important topic. I don't think there's enough information out there for people to be able to access. So the first is that I worked in Williamsport, Pennsylvania for about 7.5 years, and I worked for a law firm, and they did elder law planning as well as special needs planning. And I didn't have any experience or exposure to special needs planning prior to working at that law firm. And so when I started working there, I got my first experiences with helping families with individuals who had special needs. And so it was always in relation as me as a professional and clients and helping them and their families. And while I was living in Williamsport, I have 3 sisters. Everybody who's listened has heard me talk about each of them. And my sister Krista, she's my older sister, she has 2 children. And while I was living in Williamsport and working at the law firm there, she found out that her daughter, Audrey, had special needs. And so it's a seizure disorder that Audrey has. And it was interesting because I have to admit, I'd always looked at it from the standpoint of a legal professional and not really from the standpoint of a family member and how this type of planning can really impact them. So I wanted to talk a little bit about the legal aspect of things, because that's so important. You need to have a legal professional who knows how to plan in this area. But I also wanted to talk a little bit at the back end of the presentation just about how to help support the family and some documents that we can have in place to help ensure that we're making sure that that individual with special needs has the support that they need in their life. So for example, Audrey, my sister, has been so good with her and has figured out what works for Audrey and what doesn't work for Audrey. And that's everything from medicines to certain therapies that work for her. She, for a while, went to a riding center and did riding therapy. And so it's nice to have all the legal documents to support what we legally need to get done, but it's also important for individuals like my sister and her husband to be able to capture and document what they have found has worked in their experience for Audrey. And so I'm going to talk a lot about a document that we call Summary of Our Wishes and how that can help someone like my sister and her husband and their family make sure that they are providing for Audrey, not just in the legal sense, but also writing out what works best for Audrey, what her schedule is, what therapies work, what medicines, her therapist, their contact information. So I wanted to bring that aspect into our presentation as well, because what I found in my personal experience is that is just as important. So we like to do the legal documentation, but then we also like to come aside and offer just support in that area that's technically not legal advice, but I think it's just good practice for families. And then the second situation that I had an experience with was last year, a friend of mine, his father was in an accident. Unfortunately, it was a fall, and he had to go to a nursing home to receive long-term care, and it was unlikely that he was ever going to be discharged from the nursing home, and his dad was only 60 at the time. And through talking with him, being his friend, I had learned that he had a brother who had special needs and who had qualified for SSDI, so Social Security Disability Insurance, through his parents. And so he had an adult brother who, based on that category of special needs that he had, it was we were able to do planning for his dad that allowed dad to qualify for Medicaid and for us to be able to protect assets. So his brother, who's in his late 20s, after his dad passes away, will be protected and cared for while still being able to receive his benefits. And I was shocked because when I was talking to my friend, he said, yeah, I reached out to an attorney and she told me there's nothing I can do, that everything's going to have to go to pay for dad's care, and my brother won't actually receive any funds. And I didn't know a lot about the situation initially. I just knew that he had a brother with special needs. And so I said to him, I said, well, we can do planning that allows your dad to immediately qualify for Medicaid to pay for his long term care. And what that does is that frees up dad's assets to be there for his brother so that my friend can continue to provide and support his brother as his brother ages. So I thought that was really important because both personally and in my professional life, I've seen how impactful this type of planning is. So today, the goal is just to get the information out. So I encourage anybody who's listening to this, if they know somebody, if they know a family, or even a financial advisor, an accountant who has clients with families dealing with an individual with special needs, to just get this information out to them so that they have it. That being said, let's actually get into the legal aspect of things. So I also gave the two examples because in one example, we're dealing with an individual who's a minor. So my niece, Audrey, is a minor who has special needs and how we plan for her. And then my friend who has the brother with special needs, how do we plan for him as an adult? And so I wanted to be able to look at it through those two different lenses as we're talking about this. So the first thing is that if you do have an individual, so in my friend's situation, his brother is highly functioning, meaning that he is able to work. And so he's able to execute, he has capacity, legal capacity to be able to execute powers of attorneys. And so the first thing I did when I was talking to my friend is I said, well, does your brother have a power of attorney? And in this case, he was going to name my friend as his agent. He said, no, he doesn't. And my concern for that was when his dad passed away, my friend would have had to petition a judge in order to be named the guardian of his brother to be able to continue to handle his finances and do everything he'd need for his brother. So one of the first things we did as part of his brother's special needs planning was to have his brother execute powers of attorneys. And the MVP, the most important of that, is the financial power of attorney. So yes, we want the healthcare power of attorney and the living will to also be executed, but the most important one is the financial power of attorney. And why is that so important? Well, it's so important because without that, my friend can't deal with any bank accounts. He can't deal with any real estate. If his brother would get in any type of litigation, he can't handle that for him. He can't transfer assets, create a trust, make any gifts, update any beneficiary designation. So it's so vital that if the individual with special needs has the legal capacity to be able to execute financial power of attorney, that they actually execute the document. Now, I understand that there will be some individuals who, once they reach age 18, they don't have the mental capacity to be able to execute those documents. And in those cases, then you do have to go the legal route of a guardianship. But most of the time, in my experience, when you have an individual with special needs, they still may have the capacity to execute a financial power of attorney. And that's always the easiest route for the family. It's easier because you don't have to have court involvement, and it's also less expensive than having having court involvement. So I always encourage families to meet with an attorney. The attorney can meet with the individual with special needs and determine if that individual has legal capacity to execute a financial power of attorney. Now, why do you need one? So there's a common misconception that a family member, a spouse, a brother, a child even would have the legal ability to make financial decisions, and that's not the case. If someone is over the age of 18, then there either has to be a guardianship in place or there has to be a financial power of attorney in order for somebody to be able to handle that individual with special needs, in order for them to be able to handle their finances. So a guardianship, the problem with that is that usually it takes about 3 months to get the guardianship in place. That's the average. And it's more costly to do that. So a guardianship can be a couple of thousands of dollars, depending on what the legal work involved in and how long it takes. Usually ballpark, it could be anywhere from 2 to 5,000, depending on the amount of hours that it takes to do that. Where a power of attorney, you can do that for a couple $100. It might just be $200 or $100, even whatever it is that that legal professional is charging for that document. That's the charge for it. So there's no court intervention. There's no additional work that needs to be done. So it's more cost efficient, and it also saves time and resources. And then that individual with special needs can appoint the person they feel most comfortable with. So in the situation where my friend, it happened to be him as the brother, but maybe it isn't. Maybe it's a friend, or maybe it's a parent. Um, we always want to empower those in our lives to be able to make the decisions about who should be the agent under the power of attorney. So I always encourage people to at least consult with a legal professional to see whether that individual does have the ability to execute a power of attorney. The important thing to remember is that it's always good practice for the attorney who's meeting with that individual with special needs to meet with them independently. So a lot of times I might have where a brother or a parent brings the individual with special needs into my office so that I can evaluate whether or not they can execute a power of attorney. And I try to make the individual feel comfortable, but I also want them to feel comfortable enough to say who they want to appoint. So typically I will ask anybody who's coming with that individual to wait either in our reception area or in the hallway until I have the opportunity to talk to the individual, because they have rights too. And our job as legal professionals is to make sure we're protecting them. Now let's talk about minor beneficiaries. That would be children. So like my niece, how do we handle those situations? So in that situation, my sister and her husband would be the guardian until Audrey reaches age 18. So the thing that my sister needs to be aware of is that in her will, what we want to do is we want to provide clauses or provisions in the will that address who would be the guardian of that individual. So in my sister's case, in her and her husband's case, we might in the will actually appoint who the guardian is. And that would be the person who's physically responsible for Audrey. That would be where Audrey is living, who's in charge of making sure that her well-being is cared for. If you have an adult, so in a situation where you have somebody who's maybe 25 and they don't have the capacity to execute a financial power of attorney, maybe mom and dad have obtained a guardianship or will obtain a guardianship. In those cases, I still recommend that mom and dad put in their will who their preference is for a guardian. That individual is still going to have to petition in order to be appointed that guardian, but it carries a lot of weight with the judge who is listening to that petition of who should be the next person in line. So for example, if my niece wouldn't have capacity at age 18 to appoint a financial power of attorney and something happened to my sister and her husband as guardians, if they had obtained a guardianship, what I might tell Krista to do is in your will, you should put who your preference would be to serve as the guardian for Audrey. And again, it doesn't mean that it's binding, but what it does do is it does guide the judge and whoever the judge is to be able to make the best decision for that individual. So I always recommend that you still put that in there, even if the individual with special needs is over the age of 18. The other important thing is I don't think as legal professionals we use standby guardianship forms enough. So a standby guardianship form is something that Pennsylvania, the statute provides for, and you can take that form document right from the statute. So what we do is we have a form where if I have individuals with underage kids, usually I just email them the blank form so they can print it out whenever and fill it in. And what it's designed for is if my sister and her husband were traveling, let's say, and Audrey were staying with me, I might do or encourage my sister to do a standby guardianship form because maybe I'm not named the permanent guardian. Maybe I am just caring for Audrey for that weekend. And so, what that would allow is for me to be able to, during that period my sister is away, to be able to get medical treatment or seek medical treatment if Audrey would need that during the period that I'm caring for her. That applies to anyone with minor children, but I'm just reminding everybody that that also applies to that individual with special needs too. So if you have minor children or if you know somebody who has minor children, anytime that you and if you're married, that spouse who would be the guardian are traveling and you're going to need the person who's providing care for that minor child to be able to, for example, take them to the emergency room and seek treatment, you can do a standby guardianship form just for that period that they're caring for that individual so that you might name a permanent guardian. So my sister might actually name my parents as the permanent guardian for Audrey if something would happen and they passed away. But for that weekend, I'm the person who could take Audrey to get treatment. So you want to use the standby guardianship form in addition to also having a guardianship provision in the will for minor beneficiaries. The other thing is that I wanted to remind everybody that you need to keep your beneficiary designations updated. So in the next portion of the presentation, I'm going to talk a little bit about trusts and Pennsylvania ABLE accounts. And so when you're using these tools to help plan for an individual with special needs, you want to keep your beneficiary designations updated. So for my sister, for example, if she and her husband ever created a special needs trust for Audrey, and let's say they had a retirement account, they might have each other listed as the primary beneficiary, but then the contingent beneficiary may be their children equally. So I have a nephew, so it might be 50% to him and 50% to Audrey. But if we have a special needs trust or supplemental needs trust created for Audrey, we don't want to designate Audrey outright. We want to designate that special needs trust for her benefit. So making sure that if there's anything with a beneficiary designation, whether it be life insurance, retirement, an annuity, or even a transfer on death or a pay on death designation, you want to make sure that those designations are updated to include that special needs trust if you're using that as part of your planning. Now, before we get to the trust, Pennsylvania has created a nice mechanism in which you can protect certain assets for an individual with special needs. And they did that a couple of years ago with the ABLE account. So it's called a PA ABLE account. And this is a tax-free way to save for disability-related expenses while maintaining government benefits. So a lot of times we see people use an ABLE account if maybe they don't think it's cost effective to set up a supplemental or a special needs trust. Maybe it's an individual with special needs who has qualified for benefits, and so they want to set up an ABLE account. So it's almost like an UTMA account is the equivalent to it. And what this allows the person to do is to have this account and still qualify for whatever government benefits they're receiving as long as they meet the requirements for this account. So I wanted to go over these accounts with everybody just so everybody's familiar with it. This is not a legal document you have to go to an attorney for. This is something where you would go to the institution and create an ABLE account, set it up with the institution. That being said, if you have questions about it, or if you're not sure what's right for me, whether it's an ABLE account or a special needs trust, that's where your attorney or legal professional can help guide you. And in some cases, the recommendation would be to actually have both. And the reason for that is that depending on, we're going to get to this in a second, depending on whether you have a first party supplemental needs trust or a third party supplemental needs trust, there may be a payback provision in the trust, meaning that when that individual passes away, anything left in the trust pays back to the Pennsylvania, the state. And so an ABLE account, even though the law can allow for a payback provision. Right now, Pennsylvania is not enforcing those payback provisions. So if you have money left in an ABLE account, it may not all go to the state, I guess is what I'm saying. So sometimes you may use them in conjunction with each other. You may have an ABLE account up to the maximum and then also have a supplemental needs trust as well. So let's talk about the requirements for a Pennsylvania ABLE account. So you can contribute up to $15,000 each. So the federal limit, that's going to be adjusted based on inflation. So right now that's $15,000, but that can increase. So it used to be $14,000, now it's $15,000. As that increases, that's going to increase the contribution that can be made to an ABLE account. And that's an annual amount, okay? And that can be exceeded by the account owner if they're employed. So we're going to talk about that. That would be if it's the individual with special needs who's actually setting up the ABLE account and they happen to still be employed. Then that $15,000 might actually be increased. So that's what the next bullet point says. It says Pennsylvania ABLE account owners who earn income may contribute additional funds beyond the annual $15,000. Family and friends can contribute to the account. So it's like almost like a 529 plan. You can set it up and anybody can contribute to it. But again, the maximum for 1 year is $15,000 and that's annually. So what that means is that contribution limit applies to the total contributions, not per contributor. So if my sister Krista set up an ABLE account for Audrey, it means that my parents couldn't each contribute 15, or it doesn't, like I couldn't also contribute 15. It's 15 per year for that individual. So if both of my parents and I wanted to contribute, we'd have to divide that among all of us. The maximum amount that an ABLE account can hold right now is $511,000, around that. It's the exact number on the PowerPoint there. And once you reach that limit, no additional contributions can occur into the account, but interest can still be earned on that account. So it just means you cap that, and then after that, no more contributions can be made. But if it's invested and there's interest being generated off that account, that's fine. You can deduct contributions for Pennsylvania income tax purposes, not federal, but for Pennsylvania, but that's only if the contributions are made to a Pennsylvania ABLE account. So if you have a family member who's in another state, each state has different rules for ABLE accounts. So if you live in Pennsylvania, but you're contributing to a family member who has a Maryland ABLE account, you can't deduct it off Pennsylvania tax. It has to be for a Pennsylvania ABLE account. You can also roll over 529 accounts to a Pennsylvania ABLE account up to the contribution of limit. So right now that's $15,000 a year. So you could roll over that amount annually from the 529 plan. You can also contribute Social Security benefits, so SSI or SSDI benefits, into the Pennsylvania ABLE account as a direct deposit. Now, that would be if, in the situation with my friend and his brother, in that situation, my friend was the representative payee for Social Security purposes. So his brother was eligible and received SSDI benefits, but my friend was actually the rep payee. So in that situation, the direct deposit could not occur of the Social Security benefits because my friend was the rep payee. You can only do it if the person sets up the ABLE account and that person is receiving the Social Security benefits. Eligible individuals who can enter into contracts can be the account owners, and they would have complete control over the account. So for example, if you have somebody who's over the age of 18 and they have the capacity to execute a financial power of attorney and they have the capacity to enter into a contract, they themselves can set up their own ABLE account. If they don't have the capacity, then a trustee or representative would have to do it. But if they're able to do it, then no trustee nor is a representative needed in those circumstances to set up the contract. And the individual, if they have capacity to enter into the contract, they have complete control over it. If the individual lacks capacity or is a minor, so for example, my niece, Audrey, we wanted to set up an ABLE account for her, it would actually have to be the guardian or the agent under the financial power of attorney would have to open the account. So the other important thing is when we're talking about financial power of attorneys, make the connection here in the sense that you have to have a financial power of attorney that allows your agent, that's the person you've appointed, to set up an ABLE account. So you want to make sure if you have somebody with special needs who has a financial power of attorney in place, look through the document and make sure that the agent does have the ability to set up an ABLE account. Other things to remember is the account owners, once they reach age 21, as long as they have the capacity to enter into contracts, they can request termination of the fiduciary's authority and roll it over into a new account for themselves. Okay, so that was the Pennsylvania ABLE account. So I like to start off with that because a lot of times we have clients come in who want to know, are there any ways to provide for this individual without having to go the route of trust? Now, I have a preference for trust. I think they offer a lot more flexibility, a lot more protection, but not everybody feels comfortable with a trust, and not everybody has the means in which to fund a trust. So it's great that Pennsylvania now has the ABLE accounts that allow everybody the ability to set up these accounts as long as you meet the requirements that we just went over. But let's talk a little bit about a special needs trust. And first, let's talk about why you want a special needs trust versus an ABLE account. So like I said, a lot of times we're going to recommend that an individual with special needs actually have both. And there might be reasons, like I said, for the payback provisions, why you want to do that. But the reason why I like special needs trust or supplemental needs trust is because there's no maximum of the amount of funds that can be transferred into this account. So the ABLE account has about $511,000, which is the maximum amount. If you have somebody who's going to be the beneficiary of maybe it's some sort of lawsuit where they maybe got the special needs or didn't have it, but it was an injury that they acquired from something and they're getting some sort of settlement, it might be over $500,000. If they're the beneficiary of an estate, depending on the value of the estate, it might be more than $500,000. Or if you're having multiple people contribute, it might be more than the $500,000. So this just allows you to be able to fund it with a larger amount, and there's no contribution limit. So remember, the ABLE account every year, the cap is $15,000, and that's not per contributor, that's per person with an ABLE account. So when you have a special needs trust, there's no limit. So people can contribute as much and as many people as would want to contribute. So there are a couple of types of special needs trusts. So there's a third-party special needs trust, and if I were to rate which is the best, my preference is always to have a third-party special needs trust, and I'll explain why as we go through it. But there's also first-party special needs trust, and then there's what we call a pooled trust. So let's talk about all of these different types of trusts and how they work for an individual with special needs. So the purpose of a special needs trust or a supplemental needs trust, and we typically abbreviate that as an SNT. So anytime I'm talking about an SNT, I mean either a supplemental needs trust or special needs trust. And I use those terms interchangeably. What I've noticed is that clients might have a preference. Some people prefer supplemental needs trust, some people prefer special needs trust. So it doesn't really change the substance of what the document is saying. It's just a preference as to how we're referring to the trust. So the purpose of it, and this is really important, in order for the trust to still allow the individual to qualify for whatever benefits they're currently receiving, as well as receiving inheritance, basically, so that they can receive the inheritance and it does not jeopardize their ability to qualify for the government benefits, there has to be this particular language in the trust. And so I took it right from our trust. It has to supplement but not supplant. So what that means is it can provide support for the individual, but it can't replace or pay for anything that that government benefit is designed to pay for. So for example, if an individual is on SSI, the funds in the trust cannot be used for shelter or food. So this language is saying it can supplement other needs that that beneficiary may have, but it can't supplant, it can't be used for those particular benefits because that's what the government benefit is designed to cover. So it can supplement, but it cannot supplant whatever benefits and services the primary beneficiary. And let me stop here for a second and say, you can only have one beneficiary for a properly drafted special needs trust. You can't be a special needs trust where it provides for all of your grandchildren. My parents would actually have to, if they were to do this for Audrey, set up a separate trust that says that it's for the sole benefit of Audrey. Okay. And then what they would do is in their will or through their beneficiary designations, they would designate a percentage or a portion of their estate that paid to that. Okay. So it's to supplement but not supplant whatever benefits and services the primary beneficiary may from time to time be eligible to receive by reason of age, disability, or other factors from federal, state, and local governmental and charitable sources. So this is taken right from the language of our trust, just so that we're very clear, because it has to spell out very plainly in the document that it can supplement but not supplant the benefit. And the example again was the food or shelter. And then otherwise, the trustee of this special needs trust, this S&T, has the discretion to distribute for whatever the beneficiary needs. So let me talk a minute about how to figure out who you want the trustee to be. So if I were advising a client, let's just say it was my sister and her husband, what I would say is that when you're picking the trustee, you want it to be somebody who is familiar with the situation, but also can follow whatever guidelines that individual is benefiting from. So for example, I'm not going to go out and pick just anybody to be the trustee, because the trustee has to be familiar with the benefit that that beneficiary is receiving. They also have to be familiar with what needs that beneficiary has. So this is a very particular trustee that you want to appoint. We have some great corporate trustees in the area, and we have a lot of family members who could serve as trustees in situations. So sometimes we might say we'll have, a corporate, maybe a bank. For example, I know F&M does a great job of it. There are other institutions, but that's one of them who I know does some great work there. So it could be that it's the corporate fiduciary and a family member, or you could just have it be the family member or the corporate fiduciary. So you want to make sure that you're thinking through that, and it needs to be that you're reaching out to that institution and making sure, hey, can you serve in this position? How do we properly appoint you? So the attorney needs to actually have the specific language that that institution or that individual is requesting to be in the document. And then you have to make sure that that trustee feels comfortable with the guidelines. So for example, the other week I was talking to an accountant in the area, and she mentioned that she had a client who was setting up an S&T, a special needs trust, and they had asked them to serve as as the trustee for the beneficiary. And she said, I'm just not familiar enough with the rules here, and I don't feel comfortable with it. Do you have somebody who could serve in that role? And so what we did at that point is we said, okay, here are some options of either some corporate institutions as well as some accountants who we know have offered to do that or done good work in that area. So again, it's matching with the situation as well as who has the knowledge to be able to do that. And in this situation, we need whoever we're talking to be honest about whether or not it's realistic that they could serve as the trustee. Okay, so third party special needs or supplemental needs trust, these are situations in which the grantor is usually parent or grandparent, can be the trustee during life, and they're the ones who are setting up the trust, okay? And then this is the critical part. It's commonly funded through the will or life insurance of the person who's setting it up, okay? Meaning that any asset owned in this third party special needs trust didn't come from the beneficiary themselves. So in this situation with my friend and his brother, my friend's brother, has a job. And so he cannot take the money that he earns from his job and put it into a third party special needs trust. That's not how it works. But my friend's dad could set up a third party special needs trust and have my friend, the brother's inheritance pay into that. Okay. So you can do that. It's all about whose assets are funding the trust. If it's somebody else, it's third party. If it's the person with special needs, it's first party. Okay. So the important thing about a third party is there's no payback provision. So a third party special needs trust, what that means is the individual still qualifies for whatever benefit they're qualified for. In addition, they have this pool of money that the trustee can make distributions to supplement but not supplant the benefit. And when that individual special needs passes away, the trust can say where those funds go. So it could be goes to a sibling, could be it goes to children, but it's not going to the state. That's the important thing to remember. There's no payback requirement in a third party special needs trust. So when we're talking about, I used a picture here as a reference, this is a trust that's built in somebody else's closet. This is a trust, let me rephrase. If we think of a trust as a closet, this is a closet that's built in somebody else's house, meaning it's not my own assets if I set up the trust. Sorry, I hope that makes sense. Third-party special needs trust can be either irrevocable or revocable. So a lot of times we'll set them up as revocable during the parent's life. So in my sister's case, she may set up a third-party special needs trust for Audrey, and it may be revocable while she and her husband are living, and then it becomes irrevocable at the second spouse's death. That's when you would get the EIN. Okay, the EIN is the taxpayer identification number for the trust. And as long as it's revocable, you don't get one until both spouses have passed away. Or if we're dealing with a single spouse, or a single parent, it's just when that individual passes away. It's fairly flexible. A revocable one can be changed at any time. And again, the whole point of a revocable one is really just sitting there as a container to receive assets when somebody passes away. You can make it irrevocable. So in the situation I talked about with my friend, his brother, and his dad, in order for dad to qualify for Medicaid, we set up an irrevocable special needs trust for brother. And what we did is we transferred all the assets into the trust, and that immediately qualified dad for Medicaid. So in that case, if we're making the comparison between a trust and a closet, a revocable trust means that you've set up a closet, you've shut the door, but you can then open it and pull assets out or change any terms of it. An irrevocable trust means you set up the closet, you transfer assets into it, you close the door, you lock it, and you give the key to somebody else. So in my sister and her husband's case, if they're not themselves trying to qualify for Medicaid, it can be revocable until they die. In my friend's case, we were trying to get dad to immediately qualify for Medicaid. So we set up the special needs or supplemental needs trust and transferred assets into it, and dad immediately qualified. What I realize in my practice is there are actually a lot of situations where we may have parents who are in their 70s and 80s who are going into a nursing home, and they have a child who's either qualified for SSI or SSDI. And in those situations, there's no look back period. We can set up a supplemental needs trust, transfer assets into it, and get mom or dad to immediately qualify for Medicaid. And so what it does is it sets those assets that mom and dad had into a trust to benefit their child with special needs, and they immediately qualify for Medicaid. There's no look back period. And that's just because Pennsylvania does have a pretty strong public policy that if we have an individual with special needs, we don't want to take those funds. We want it to be there so that they don't have to qualify for any type of Medicaid at some point. So that's why we have that rule. So I wanted to bring that up because a lot of times we have situations where we're dealing with mom and dad and they do have a child who has special needs and is qualified for SSI or SSDI, and there's no look back period. So just remember that whether it's you, somebody you know, or a client that you have, supplemental and special needs trusts are important not only for the individual with special or supplemental needs, but it's also important for mom or dad if they're trying to qualify for Medicaid benefits. And that's why it was so upsetting to me when my friend reached out and said that he had talked to an attorney, and the attorney said there was nothing that could be done, that all the assets were going to have to be used for dad's care. That's not true. You can protect those assets for the brother in that situation. Okay, let's talk about first party supplemental or special needs trust. So if we're thinking about the trust concept, this is a trust that's built in the house, your house. So the individual with special needs in their house. So it's not far enough away from them to have complete protection. So you get some protection, but not complete protection. The common misconception with first party special needs trust is that it still has to be created by a parent, grandparent, the guardian, or a court. So in the situation with my friend and his brother, the brother could not set up a first party special needs trust or supplemental needs trust for himself. You cannot do that, okay? It still would have had to be created by dad or by the brother, okay, through a court order, because again, it's parent, grandparent, guardian, or the court. So it's not who sets up the trust. That's not what determines whether it's first or third party. What determines is whose assets are funding the trust. So in the situation with my friend, it was dad's assets funding this trust. So in that situation, it was a third party supplemental needs trust. If dad had set up the trust and brother's assets were funding it, we'd have a first party special needs trust. So that's what determines whether it's first or third. It's whose assets are being transferred into the trust, not who sets it up. because in the situation we're talking about, an individual with special needs cannot create their own trust and still be able to qualify for benefits. Okay, so I wanted to make sure that was clear. The other thing I wanted to mention is when we're talking about powers of attorney, so in the situation with my friend and his brother, dad had fallen and wasn't able to set up this trust, but he had executed a financial power of attorney, giving my friend the ability to create a trust. And the power of attorney had to specifically say an irrevocable trust. If it didn't say that, then my friend would not have been able to do this. So that's the other important thing is you have to look at it from the big picture, which is it's important for your document to allow your agent to set up an irrevocable trust. Because if you don't have the capacity to do it, you may need your agent to do that. So in this case, my friend was able to do it. He acted as if he was dad. So dad didn't actually set it up, but my friend, acting as dad under the power of attorney, was able to set up the trust. So it was a third party special needs trust because then dad's assets funded it. Okay. A first party special needs trust needs to be approved by the Pennsylvania Department of Public Welfare or Department of Human Services now. It's a good idea to also send it to the Social Security Administration and get them to also agree to it. Because remember, these are the beneficiary's assets in a first party supplemental needs trust. So we need to get approval in order for you to be able to use this type of trust. It's always going to be an irrevocable trust. And there's going to be payback provision, which means unlike in the third party special needs trust, where you could say when the individual with special needs dies, this is where the remaining assets go. In this type of trust, it goes to the state to the extent that the state provided any type of care. Okay, so that's what that payback provision means. And so that's why if you want to get the gold star of trusts for special needs or supplemental needs planning, it needs to be the third party special needs trust. There's also a pooled trust, and we see this a lot if you want to group together assets to maybe invest them, and you can also do it by, it's established by the beneficiary, the family member, or the guardian. So remember the first and the third, so the third party and the first party supplemental needs trust, the beneficiary can't create it, but with a pooled trust, the beneficiary can create it. And so what happens is it's administered by a nonprofit and you're pooling management of, couple of individuals that have special needs. And a pooled trust would allow the beneficiary to actually create the trust. And so that's why we have the three different options of the type of trust you use. So tips to consider for the special needs or supplemental needs trust, you have to consider what your goal is. You have to pay careful attention to the trustee. Beneficiary themselves cannot have access. It has to be the trustee who makes distributions out. And then funding the trust, it has to supplement those government benefits, not supplant them. And it's all about providing and maintaining the quality of life for that beneficiary. Structured settlement, we have some clients who may have been awarded a settlement, and so the timing is important. We always recommend the trust first before the settlement comes in so that you can actually have the settlement pay into that. And because it's usually a settlement related to the beneficiary, most of the time it's a payback trust, which would mean it's a first party special needs trust. So again, we still have to have somebody else set it up, but it's going to have a payback provisions because it's funded by assets the beneficiary was entitled to. Okay, so that covered the legal aspects of it. And like I said, at the end, we'll do a question and answer section if anybody has any questions about that. But I think it's important to take a step back and think about how the family has been providing support for all of these years for that individual. And again, this really didn't hit home until I was watching my sister and her family deal with that. So here in our office, we recommend, so you don't have to do it, but we highly recommend a summary of our wishes. Okay, and so this is a document that communicates future plans to caregivers, provides some understanding of the eligibility for the public benefits that beneficiary is receiving. And it also kind of outlines the plan to utilize public and private resources. And this is a written document that our office is happy to help the family facilitate. So we actually have a packet that we provide to the family, and the family is going to go through and answer some questions and, provide some explanation and some guidance as to what they would want. But what we use is we use our document as a thought-provoking piece to get them to really document what they think that individual would need in the future if they're not there. So what I did is I took excerpts from the summary of our wishes so that you could understand kind of what the goal and the purpose of this document is. So it's really a summary that is to provide guidance to the individual or to the individuals who are going to be providing care or the caregiver for that individual's special needs or supplemental needs. If the primary caregiver, so if parents or the guardian would pass away or incapacitated. So it's really creating a vision. And here we're using the example of if it would be a son. So it really represents the vision for that child and contains details that will help guide anybody with the well-being of that individual. So it's to be considered binding to the greatest extent possible. And we recognize, this is what the document says, we recognize there may be circumstances or decisions that are beyond the scope of our anticipation. And we request that all parties concerned act in accordance with the wishes expressed here. And we direct the son's guardian to be aware of and carry out the wishes and visions related to the personal care, nurturing, education, spiritual development, and social growth of our son while acting in their capacity as a guardian. We further direct our trustee to support our son's guardian to the greatest extent possible. So remember, it might be different individuals. You might have a trustee and you might have a guardian. They may be two different people. They could be the same person, but they may be different. So it's just saying we direct that the trustee is to support the guardian so that they may be able to implement the vision as they care for that child. So all of this information is done to continue to benefit that individual with special needs. So let's talk about what's all in the summary of wishes document. So there's some initial instructions, which just says upon death or incapacity, son or daughter will become the responsibility of the appointed guardian identified as, and it would just name, address, and phone of that individual. Upon our death or incapacity, and as soon as our son or daughter is placed in the custody of that guardian, please notify the following friends, family members, and organizations of our death or incapacity and the location of our son or daughter. So, for example, with my niece, she has, just like so many individuals I've seen with special needs, she has created so much joy for those around her. She is just the sweetest soul. And so there's so many people that care about Audrey and that are invested in her well-being. So this would allow my sister to put, whether it's, church members that have helped support, whether it's family members, whether it's friends, it just lists the individuals that you would want to be notified if you have passed away or incapacitated, and you would want them to know, where is my child or the individual with special needs? Where are they now at? How do they contact them if they would want to do that? Because the whole goal in this is to maintain as much as possible that environment for that individual with special needs. Then there are a whole bunch of miscellaneous instructions. And what I tell clients is it can be a little overwhelming, but you do or fill it out to the extent that you feel comfortable. The more detail, the better it is. So our goal is to try to capture the big picture, but if there are things that you don't really want to detail or you don't think you need to detail, you can skip over those sections. So, for example, telling that individual with special needs about a parent or the guardian's death or incapacity. So it spells out specific instructions. We ask that you talk to our son or daughter about our death or incapacity in the following manner. Who better to explain what the best way to do that is than the people who have cared for this individual for years? It also then goes on talking about the living situation. So you want to make sure that family, friends, and organizations are notified of that and know what the living situation is. So it talks about that, it talks about advocacy. So it's talking about, it's going to guide these new individuals who are part of them about how you want them to advocate for that child with special needs. And then we have a section about important details regarding family involvement. So, just even knowing, like, how does this individual spend holidays? So I was just dealing with a situation where a mom was telling me that, daughter with special needs was handling a death in the family, particularly was having a particularly difficult time. She was talking about how she handled the situation, what she told them, how the bedtime routine is, all of that, how, certain individuals brought them comfort. They could stay at certain family members' houses, but not others. All of this should be outlined here in the summary of our wishes. Also continuing the vision for religion and spiritual growth. So just knowing what do they want in that situation? What are the religious traditions? What routines? What values? Things about church? All of that can be in here. An overview of the medical history and current treatment needs. We like to spell out that. Educational preferences for son and daughter. So what works best? How would they want the education to proceed? Activities and recreation. So I know this is going to seem odd to have to detail this, but my niece, again, went to therapy. She rode a horse, and what would happen is her seizures would be reduced dramatically once she'd had a session where she was riding. They would do different activities with her and the horse. She'd ride backwards. She'd have to ride with her arms out to work on her balance. And as soon as she was done that therapy lesson, she was much more verbal than she normally would be. And so there's something about the way the brain works with therapy. And so knowing that, what hobbies, what interests, my niece also likes to jump on the trampoline. She has certain therapies that she works on for her coordination. She works on skipping, things like that, that my sister could outline here so that somebody who's going to be caring for Audrey would know all of those things. Disciplining. So what works in the situation if somebody's in trouble, what doesn't work, what the preferred method of discipline is for that individual with special needs. What are the financial needs? What do they need in order to continue that same quality of life? Personality traits and preferences. So, knowing that, I don't know, that Audrey is a people person, that she likes to be around people, that she enjoys that, maybe that she wakes up slowly in the morning, that, she talks more in the afternoon. Knowing those type of things would be helpful for anybody who's going to be caring for Audrey. Other things to include would be the individual's social security number, birth date, home address, include grandparents, parents, siblings, contact information, include the contact information for the name of the guardian under the will, the relationship to the individual with special needs, their address, contact information, etc. Include the trustee of the S&T, the Supplemental Needs Trust, their contact information, the address, the trustee succession. So this is all in the summary of our wishes, that packet that we give. So this information is all in one place, and then we keep it with the estate planning document. We also have contacts listed. So individuals, organizations, professional groups, government agencies. Who do you talk with at Social Security? There may be a caseworker that's specifically assigned. So having all of that information down for the individual who's going to be providing or assuming the care. Medical information, so doctors, therapists, maybe nutritionists, whoever is involved with the medical treatment of that individual. Insurance information, having that, what hospital is preferred or used, talking about medication specifically here, what the purpose of it is, the doctor's name, the date of the prescription, including all of that in the summary of our wishes. And then non-prescription medication and equipment. So, for example, I know that there was some discussion for certain individuals for like a motorized cart or a wheelchair, or maybe certain canes or support things if somebody's walking. So having that all listed down, what the purpose of it, what the equipment is actually called, maybe where it's stored, all of those things would be important. And then income and asset information. This would be especially important if you're dealing with somebody who actually works still or is able to work. So detailing all of that, talking about, if you have a trust in place, you've already started making distributions. What are the typical disbursements from the trust? What are they used for? Any regular gifts from any family members or individuals. Then also included in the summary of wishes is just where the important documents are. So where do they have a power of attorney and advanced medical directive, and where are they? Any income and asset information like we talked about. Is there a legal guardian? Does your son or daughter have a will? Where do they keep all of this information? Do they have bank accounts, investment accounts, detailing all of that with account numbers there? Is the child or beneficiary named on anyone else's estate planning documents or part of anybody else's estate plan? And then does that individual have any online accounts? And then where are they held? How do you access those? So putting these all in a place for the guardian. Is your son or daughter active on any social media sites? And if so, which ones? And maybe even detailing how they interact with social media or the people on social media. Any PIN numbers, passwords, anything like that for the social media accounts, because the individual themselves may not have them. And so, if this is part of activities that they do to maintain quality of life, you want to make sure that the individual who's caring for them can still access all of that. And then we also have a place for end of life issues. So this parents may have planned for the end of life issues that could arise for son or daughter. Included would be, a durable power of attorney or advanced healthcare directive, and including a copy. And then any funeral arrangements that parents may have made or that, they may have talked about. And then we request that the parents in this case would sign and date it. We'd have a copy, and then the client has a copy. And we always recommend an annual review, and we just go over that every year, make sure there's no changes in anything, and keep that up to date. So you have the legal documentation, and then you have this summary of our wishes, which again is just the outline of support for that individual. So again, I think you have to have both of those, and I think they're so crucial in order to make sure that that individual with special needs is able to continue to have the same quality of life. So that's why we do this document. I know sometimes family members might think it's burdensome or really long and in depth. And again, you can always opt out of certain sections. But the few times that we've needed to use this, it's been so helpful, not just for our office, but for the individual with special needs and for the new guardian or custodian or trustee who's going to be involved. Our next monthly virtual seminar is May 4th, and that's right before Mother's Day. So we wanted to do first steps, things your mama should have told you. So Amy's putting together the presentation for that. So it's just one of our previous seminars. We had a client who said it would be really helpful. What are the first steps when somebody dies? What are the first steps I need for estate planning? What are the first steps? So just in every situation, what are the first few things you should be doing? So we're going to go over that in May. You can register for that by emailing Amy at her email address, or you can call us at our number there, which is 717-655-2676. Afterwards, Amy is going to be emailing a link for a survey. We always appreciate your feedback. On that survey, you can put additional requests for information or ideas for other seminar topics. For example, this one was a recommendation from a client. Can we hear more about that? So that's why we did this particular seminar. So with that being said, I'm going to now open it up with questions. And so what I'm going to do here is I'm going to end my slideshow, and I'm going to go ahead and stop the recording. And if anybody has any questions, I'd be happy to take them. So thank you so much. Let me stop this. Thank you for listening.